It amounts to a demand that the committee forego in-person testimony for relevant info. Like you just said, you've got a little info, but now you don't want to show up to tell us about it? Why are you trying to obstruct us? A grand jury returned an indictment in the Southern District of New York. There was a protective order saying none of this stuff could be posted. Then Epstein committed suicide. Many Republicans did too and just said, well, that's okay. If we punish Stacy Plaskett for sending texts to Jeffrey, we might have to punish half of Congress for all we know. Bill and Hillary Clinton are now on notice. They better show up for their deposition or else. James Comer sent them this letter as a follow-up to their subpoena that they got a long time ago. And remember what happens if you ignore a congressional subpoena, according to the Democrats? You go straight to jail. That's what happened to Steve Bannon and Peter Navarro when they didn't show up after the illegally constituted J6 committee tried to drag their booties in there. But now Comer is saying, all right, Bill and Hillary, no one is above the law, and now you better get in here. Saying, all right, look, Democrats and Republicans approved subpoenas in July for Bill and Hillary Clinton and many others. After good faith efforts to schedule depositions with them, further delays aren't acceptable. Given their Epstein ties, avoiding Congress would be in defiance of subpoenas, and they would warrant contempt proceedings. But then there'd have to be a criminal referral. It'd have to go over to Pam Bondi, and she'd have to do something about it. So don't get your hopes up. But here's what Comer said. Today, House Committee and Oversight Government Reform Chair Comer sent a letter to Hillary Clinton's lawyer saying, hey, we're engaged in good faith negotiations, but you better show up here or you're going to be in big trouble. Bill and Hillary, here's what the letter says. All right, Mr. David Kendall, senior counsel at Williams and Conley. All right, lawyer for Hillary. The committee has received your letter that you sent back to us outlining your arguments why you say Bill and Hillary should not be required to appear. You call it for live testimony. Now, the crux of your argument is that the committee should accept, quote, a written proffer of what little information the Clintons may have, because you think it's going to be the most efficient and equitable way to proceed. You want to just send us a love note? Now, the committee disagrees with you, David. You highlight the fact that the committee elected to forego deposing other individuals subpoenaed. And I think, who else was supposed to come? Somebody I think was brain dead, like Mueller, maybe? He's slobbering all over himself, so that they didn't require him to come in. However, your assertion conveniently ignores the fact that individuals affirmed that they lack any information or have serious health issues like others have. Okay, other people lack any information and the others had health issues, so we let them go. But as your letter indicates here, David, lawyer for Bill and Hillary, they do possess information that we want. You even said in your letter, what we have learned over the years about Jeffrey and Ghislaine is abhorrent. The public's demand for transparency from its government about their criminality is both understandable and warranted. Their lawyers are even like, yeah, it's important. Former President Clinton and Hillary welcome legitimate oversight if it's grounded in fact. And in that regard, their lawyers right. Former Bill Clinton and Hillary have little to contribute to that goal, but you do have something, don't you? Thank you for that. All of which can be readily submitted on paper. So given the admission that you just made that they do have a little, it amounts to a demand that the committee forego in-person testimony for relevant info. Like you just said, you've got a little info, but now you don't want to show up to tell us about it? Why are you trying to obstruct us? The committee sets the terms of its oversight, okay, not you, including deciding which witnesses to interview, in what order to interview them, and whether or not to compel testimony in a time, place, and manner of our choosing. Federal courts have also consistently held that you don't get to impose your own conditions on us. That's because a witness does not have the legal right to dictate conditions under which they're going to testify to us. So simply put, David, the fact that other witnesses may have been afforded certain accommodations is not a defense to a congressional subpoena. They're slobbering all over themselves. That's why they didn't come in. Now, the committee is not obligated to defer to either you or your client's determination that the importance or quantity of information is irrelevant. We decline to do that. Rather, our committee is entitled to a fulsome examination of this information, which should include the ability to elicit the information in person and to ask relevant follow-up questions of Bill. While you argue that the committee has not provided a persuasive rationale for deposing the Clintons, you say it needs to be a required bit of evidence. But that's not the standard. The committee need only conclude that it would be helpful. They don't need to have information that is required for our information. It's only if it's helpful too. Then we can ask. Therefore, the committee does not find your argument against this compelling at all. So they're coming in here in person. Now, additionally, David, your suggestion that your clients, Bill and Hillary, would not be relevant their testimony to the purposes of our investigation because it's outside of their official duties misses the point. It is precisely the fact that Bill and Hillary each maintained relationships with Epstein and Maxwell in their personal capacities as private citizens that is of interest interest to us. We're not even asking about their official duties. It's all about their private flights. And so in sum, David, lawyer, your arguments lack merit and completely ignore the lengthy rationales that we already told you about. And so accordingly, pursuant to our subpoenas that we sent back in August, these new depositions are scheduled for the following dates. Bill Clinton, get in here, December 17th at 10 a.m. in Washington, D.C. And Secretary Clinton, hang out close by, December 18th, 10 a.m. Just get a hotel together and just come in one day after another. We have authority to investigate these things, and that's what we're doing. Sincerely, your friend, James Comer, Congress. And we'll see what they say back. But that's coming up soon. We just got a couple of weeks until we can expect them to be there. December 17th, December 18th. They better be there. And if not, these Republicans, man, they better start these contempt proceedings instantly and refer those over to the DOJ. And then Pam Bondi and the rest of them can figure out what to do about that, which means they better impanel grand juries and indict them, just like they did with Steve Bannon and Peter Navarro. And they can share a cell together when they serve out their 4 months. So that came down. We also see that in the Epstein matter, the DOJ has now submitted a no and another motion to unseal the grand jury transcripts. Woo. We already saw this happen once before. We read through both of them. One in New York, one in Florida. The last time we tried to get these unsealed. But something has changed now. Congress has, of course, passed the law. So now they can say, well, not only do we want it as the executive branch, but the legislative branch has also said, release their files, please. So here is what they've submitted. This one's in the Southern District of New York in the grand jury matter that's related to the Epstein case. Says, all right, listen, Judge, at the direction of Pam Bondi, the DOJ files this motion to ask the court to unseal the files. The DOJ previously petitioned this court to unseal these records before. Back in July, we read it. The court denied that petition, saying, well, the rules don't approve any of this. Now, after the court entered its order, and we read it, we read through their motion. They're just like a sticky note, like, will you please unseal it? They're like, what? No. I'm like, okay, fine. Anyways, after the court entered its order, Congress near unanimously passed and the president signed the Epstein Files Transparency Act. There are certain exceptions, but it does say that Pam Bondi, no later than 30 days, needs to make all of this stuff available. It requires the DOJ to publish the grand jury transcripts associated with these investigations unless there's a basis for withholding them. And so accordingly, subject to appropriate redactions allowed by the act, the DOJ once again moves the court to unseal the transcripts so that we can see them. In support of this request, we also state the following. Now, based on what we know about these grand jury proceedings, I think that there's probably very little in there that is substantive. We know that Maureen Comey was leading both of these and that the indictments and the grand jury proceedings were very short in time, like one witness and PowerPoint slides, like 30, 90 minutes tops. So there's not going to be a huge trove of information that leads to other people being indicted. On July 2019, a grand jury returned an indictment in the Southern District of New York. There was a protective order saying none of this stuff could be posted. Then Epstein committed suicide in his cell. Official DOJ position. Okay. On June 29th, the grand jury then, 2020, indicted Maxwell. Okay, these are both the new cases. 2019, this is a cleanup operation. 2020, Maxwell, cleanup operation. The real crimes were covered up back in 2007. The court entered a protective order saying don't post anything about this. Jury came back, found Maxwell guilty. Nobody else was even hardly discussed at the trial. No other predators. In light of the public interest in this, we asked you to unseal. You denied the request to unseal. You also denied it in New York. Now, on November 19th, the president, Trump, signed into law the new Epstein Files Transparency Act, saying you got 30 days, release the files. They must release things, including all investigations, prosecutions of Jeffrey, Ghislaine Maxwell, flight logs, itineraries, pilot logs, vessels, vehicles, all the things, all individuals, entities, any immunity deals, internal DOJ comms. Man, that's going to be good stuff right there. But again, for what date range? Yeah. Says the act allows for certain withholdings for victims, victim information, or anything that would jeopardize a federal investigation, and also classified information, which is weird how we have classified information in just a criminal case involving just a regular standard predator. Finally, the act also requires Pam to submit a report listing what has been withheld and what is not being released. They say, we know the rules in a grand jury are to normally keep this stuff secret, but the act has given us a clear mandate. And you too, Judge, the court should authorize the Department of Justice to release the transcripts and lift any other protective orders that would permit disclosure because Congress said so. So we got 30 days. We need you to go. Act quickly on this. And so we got two branches now. The legislative and the executive branches have nearly unanimously directed the DOJ to make these files available. Specific language in the statute from Congress overrides the grand jury secrets and the rules protecting them. And so you should publicly release all of these things. Lift any and all pre-existing protective orders. Unseal everything from Manolo. We'll see what the courts have to say about that. But the Democrats are still reeling from this. It's like the dog chasing the cars who finally caught the car. It's like, what are you going to do with it kind of thing? Raskin, he's now getting called out. We saw Stacy Plaskett was scrutinized, rightfully so, for literally texting with Epstein like a puppet, getting instructions from him while on her congressional seat. And now Raskin is still trying to cover for her. Here is how that conversation went down on CNN.
Ask you about Democratic Congresswoman Stacy Plaskett. Last week, as you know, there was a failed censure effort over her text with Epstein during an oversight hearing in 2019. He was a known sex offender. She acknowledged Epstein's influence in her line of questioning during that hearing on this show when we had her on, but would not say it was an error in judgment. Here's how you defended her on the House floor last week, so our viewers can listen.
However ill-advised it may have been, she took a phone call from one of her constituents. They've arraigned a Democratic member for taking a phone call from her constituent, Jeffrey Epstein, in the middle of a hearing. And of course, I don't think there's any rule here against taking phone calls in a hearing.
And to be clear, she initiated the text chain on that day. But are Democrats losing the moral high ground on the Epstein issue by defending her as you have?
Well, look, we've been demanding a complete release of the file, and now they wanted to discipline her, censure her, because she'd engaged in that text exchange with a convicted criminal.
Yeah, she was receiving instructions from a man who was convicted to take out her political opponents, and the Democrats just rolled over. Many Republicans did too, and just said, well, that's okay. If we punish Stacy Plaskett for sending texts to Jeffrey, we might have to punish half of Congress for all we know. So the records are hopefully getting released soon, at least the grand jury portion of it, now that we've got the executive and the legislative branches both saying the courts must do it. And Bill and Hillary better get their act together, man. They got subpoenas that have been served and delivered, and we've got dates queued up for them. Get your butts in here, December 17th and December 18th, or maybe you can spend Christmas in jail. Not that the prosecution will move that fast, but maybe jail 2026. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do.